Hi, and welcome back to Politico's Tech Summit. We are starting now a fireside chat with the European Data Protection Supervisor, Wojciech Wiewiórowski. Fireside chat without any fire, just in this, this hotel. I'm Christine Gojard. I'm a tech reporter with Politico, and I'll be asking questions to Wojciech today. But first, some housekeeping rules for everyone. You can ask questions only through the SwapCard platform, the instructions for which you can find on our event website. If you're already on the platform, feel free to chat with fellow attendees and ask questions in the questions box to the right of the screen if you're on desktop, and below the live stream if you're viewing on your mobile. If you're joining us in person, you can also ask your questions also via the SwapCard app by scanning the QR code on the screen. Okay, let's start now. We have only, I think, 15 or 20 minutes, so let's get going. To talk about a much heated issue, the enforcement of the GDPR, the EU's landmark privacy rules. So you and the EDPB, I mean, you've been calling for some changes to the law, at least for some procedural tweaks, or at least that's what the European Data Protection Board asked last fall. And the Commission announced it will come with a regulation before the summer to adapt or tweak these rules in order to bolster the enforcement in large cross-border cases. What did you think of the Commission announcing this regulation? Is that what you wanted?
Well, we have to say that there are two perspectives that we should look at. The first perspective is the implementation of everything which was done in the reform of the data protection law in GDPR as it is at the moment. And I may say that this initiative from the Commission, which we see now, is a kind of follow-up of the first remarks on the practice of the implementation of GDPR. But it's actually still in the frame of GDPR as such. So there is no opening of the GDPR and discussion about the general rules, neither the general way of dealing with the subjects, but there is a possibility of harmonizing some procedural rules to make it working better. But this is one perspective. The other perspective is going with another term of the Parliament and another term of the European Commission, where we have to say we will be already more than 10 years in the discussion about GDPR changes, and definitely the new Commission and the new Parliament will start to make the review of how it all works. So there are these two perspectives. Let's concentrate on this first perspective, which is now presented by the European Commission proposal. The data protection authorities met at the summit in April last year in Vienna, and among different topics, how to make the enforcement better, according to the GDPR, they were listing some bottlenecks, some obstacles that they find both in the national legislations, but also on the cross between these legislations in the cross-border cases. And this is what the European Commission is going to address, at least as far as we know, because nobody saw the text yet. Yeah, we had the presentations from the European Commission, but we understand that this is the goal. But as I said, there is also the need to start the discussion what will happen in the longer perspective. There's no law which survives to 20 or 30 years without any adjustments, at least. So definitely this discussion will come back in the next term of the Parliament and the Council, but what we can, and the Commission. But what we can do now is what the Commission tries to propose in this regulation.
But so, are you saying this initiative is already not enough to fix the enforcement of the GDPR?
I would say there is always room for improvement. I'm not saying that the enforcement is failing. I'm not saying that the one-stop shop is not the solution to be taken. That's something which proves its good sides. But once again, if we have the whole process already tested, we can look back and see what can be done better. Now we are in the phase of the judicial control over the actions by the data protection commissioners. While Helen said just a few minutes ago about the way how we coordinate, how we harmonize the decisions of the data protection authorities inside the European Data Protection Board, there is actually no system of harmonization of the judicial review over that. So one of the things that we will have to look at from the perspective of this first years is how the judicial approach to the GDPR may differ from country to country. Of course, somebody can say there is a court of justice, so the court of justice will answer the questions about that. Well, I come from the country which is 40 million people market, 36 million people market, and there was only one question to the Court of Justice about GDPR. That doesn't mean that nothing is going on. That means that the courts in the country think that they know how to deal with it. Yeah? I guess in other countries in Europe, most of the courts are of the same opinion. They know how to deal. Now we will have to look also how this coordination looks like. So this is one of the points. The other, of course, are the really cross-border cases. So the cases which don't involve 2 or 3 countries, but involve the people from all the countries in the European Union. And moreover, the complainants are from all these countries. So the complainants are waiting not only for the solution for the future, how to deal with the subject, but also for the very harm and for dealing with the very harm and very breach that they complained about.
Mm. At one point in June 2022, you introduced the idea of a PanEuropean enforcement authority, saying it might be necessary.
We said about PanEuropean framework, as it was said by the deputy chair of the EDPB, Alid Wolfsen, that such centralization is also the one-stop shop system. One-stop shop system is centralizing the complaints from all over Europe. That's true, but we also thought about creating the kind of panel probably in the future that may deal with these really cross-border cases. But once again, this is not the solution for the shorter perspective, but rather for longer perspective. We think that the role of the European Data Protection Board in solving these cases shall be enhanced.
How would it be enhanced?
I don't know exactly what should be the answer. I think that there should be the one-stop shop shall work more or less the same way, but not necessarily with the final decision being given by one of the data protection authorities being the lead authority, but rather the European Data Protection Board, maybe not in political panel of the commissioners, but in more like it is in some of the countries with the panel consisting of special persons, appointed by the member states and by the data protection authorities in the member states to solve the problem. But as I said, there is no plan for that. There's no draft or proposal for that. Mm. This is one of the ideas which came out of the discussion in the conference which we organized in June last year. Mm.
But is this something you're hoping will happen in the next mandate?
I hope that the discussion will happen. I hope that we will be prepared for this discussion. I don't know if I know what is the silver bullet to solve the problems, but definitely we have to be, as the data protection community, prepared for this discussion. We have to have the studies on that. Once again, I will recall what Helen said about the lack of the empirical studies on what is the approach of the citizens to the changes that were done. All these have to be done this year in order to be ready from 2025 to discuss about the real review of the reform that we did in last years and which I'm really very proud of.
Mm. We're already kind of nearing the end of this interview. The chair of the European Data Protection Board, the first chair of this European Data Protection Board is stepping down at the end of her mandate, and there's an election that just started yesterday. What sort of leadership do you hope for the next mandate of this big network that can issue binding opinions on major cases for big tech companies under the specific Article 65? That's
extremely challenging job. Once again, let me remind the first meeting with the Working Party of Article 29, the predecessor of the European Data Protection Board, which I had in 2010, going there as the National Data Protection Authority, I was very skeptical. I could imagine these 30 people around the table with a high ego and being independent, especially independent one from another, yeah, and trying to discuss about something. I thought that there's no way to go to the final solution, to find the compromise between all these positions. And then I saw what is an important role of the chair. The chair, who is not representing his or her country, but is representing the European idea. Idea of the market, which is ruled by the same rules, which might be understood differently, but we know how to go to some consensus. So first of all, this leadership in EDPB is the leadership by knowing how to deal with 31 members of the EDPB with their own experiences with the markets which are as big as Germany and as small as Slovenia or Estonia, being still very influential and having a lot to say. So that would be the first thing. The second thing is that also the head or the chair of the European Data Protection Board is a kind of face of this institute, of this body, yeah, of the EDPB. So this is also the way to present it to the people in the way which is understandable and which shows this European idea over that.
I have one last question for you. I'm just checking. It don't seem to have any other question. One last question for you. We have 3 minutes. On a burning topic, that of ChatGPT. The Italian Data Protection Authority a couple of weeks ago decided to temporarily ban it in Italy because it decided it had allegedly violated some parts of the GDPR. You're the data protection supervisors for European institutions. Should, this tool is being used by everyone, should it be temporarily banned for Commission and EU institution officials? Is it too risky?
I would say, well, first of all, we didn't get any complaints yet. So the discussion is discussion of an ex officio action done by the EDPS. We decided to wait, but observe what's going on in the task force, which was created by the European Data Protection Board, in order to harmonize the approach to the ChatGPT. But I would say that there are 3 kinds of problems which we meet with the service like the one prepared by the OpenAI, which we somehow have to answer as well. The first ones are obvious for all the big services, and that was, for example, the age verification and the possibility of using that by the child. And once again, as the person whose children are between 13 and 16 and who is being asked by the platforms if they feel more Belgian or more Polish, because if they are Polish, they should be under parental control. If they feel Belgian, they are already 13 years old. So there are these questions which are directed to all the services. Then there are the questions which are directed to the artificial intelligence services, which are mainly about the algorithms and about the possibility to understand what's going on there. And then there will be the questions, data protection questions, which go exactly to this very service. And for me, the most challenging factor, the biggest concern, are so-called hallucinations. Because if hallucinations mean that to the outcome of the question that is asked to the chat, there are the things which are not true, and we don't know how to exchange these non-true ones from the true ones, then we have the data protection problem, huge problem, because we don't know actually if the answers can be used for any kind of purposes. You can try to ask the services about the funny way of presenting the things or sad way of presenting the things. Then the chat tries to be more inventive. And he starts to invent your siblings, your friends, your connections with different things, and you cannot exchange it from the reality which is there. So, as I said, all these 3 factors have to be taken into consideration, and at the same time, despite the fact that all the data protection authorities may do their own actions, because one-stop shop system cannot be used, no establishment for OpenAI, we have to coordinate these actions, because if we will have 31 answers to the questions about ChatGPT, that will be the disaster from the data protection point of view.
But so no temporary ban for EU officials?
No temporary ban so far, no temporary ban, but we are happy that both Europol and also the Council started to look at the practice of Europol does it for the law enforcement authorities. Council prepared the first kind of survey on how it is used by the public authorities in the European Union. At least we can map the situations in which the services like that, because this is not only OpenAI, are in use. I don't think that we should start from the ban, and at the same time I think that for the EU institutions, that's not only the legal question, that's also ethical questions, though I don't like the lawyers to say that something is an ethical issue.
Any fears that the Commission will use ChatGPT to come up with its regulation on procedural rules for GDPR?
Once in 2016 I proposed myself that there should be the artificial intelligent entity that would answer the questions about accountability from the position of the controller of some system. And then if such a complicated answer would be prepared under GDPR by this entity, it should be sent to the Data Protection Authority, on which side there should be an entity which is artificially intelligent, who will assess the assessment which was done by the entity. And then, you know, they can exchange the data between itself for the rest of the universe time, and we will have the typical discussion without the answers.
Thank you, Mostek, for this amazing answer. Thanks everyone who came for this panel, and thanks for those of you who are watching online. You can stay seated for the next session called "To Regulate or Not to Regulate: An Uphill Battle to Get Tech Standards in Line," moderated by my colleague Mark Scott. Thank you again.
Thank you very much.
Thank you.